Okay, we're live.
Hello, all. Welcome to Joseph and Hall's weekly update on immigration. My name is Aaron Hall. I'm here with Rylan Warner, Jennifer Howard, and Zach New. And we'll each, as always, be giving a quick update on something happening in the world of immigration. And then we will get to any questions that are posted. If you're watching this video later and not live, then of course you can reach out to us, or we will be back live next Thursday. So you can always tune in Thursday and get your questions in live. So with that said, should we just get to it? I can start with my update.
Sure, sounds good.
Okay. I'm going to talk about something called the 3 and 10 year unlawful presence bars. And I'll give a little bit of background because there's been a big change that's going to help quite a few people. The law says basically that if somebody accumulates more than 6 months of unlawful presence and then departs the United States, it triggers a 3-year bar to admissibility. And if they accumulate more than 1 year of unlawful presence, then it triggers a 10-year bar of inadmissibility. So the statute says that it's triggered with the departure from the United States. And this normally comes up when people leave to go try to get a visa at the consulate abroad because they've been here unlawfully, then they leave, and upon departure, all of a sudden they're ineligible to come back unless they had a waiver. For many years, what the agency said is that for people who leave and then come back on like a tourist visa or another non-immigrant visa, that the 10-year bar is still running while they're back in the United States. And then about 8 years ago, maybe something like that, certain parts of USCIS, not consistently, but certain offices started saying, actually, no, if you come back on the same tourist visa while that 10-year bar is running, then it stops running. And so if you do that and you later apply for adjustment of status, you're actually still inadmissible with that 10-year bar. So to give a concrete example, if somebody had a tourist visa and they entered the country in 2000 and then they overstayed until 2005, but then they left to go to their home country for a visit and re-entered on the same tourist visa. So they presented the visa and were just allowed back in. And then they want to apply for adjustment of status in 2012, after the 10-year bar had run. Did I do that math right? Okay, let's just say 2018, because I'm not sure when I said the exit was. So they want to apply for adjustment of status in 2018. Then they should be able to, right? Because it's been more than 10 years since that departure in 2005. So USCIS started saying no, because it stopped running when you came back in. And they got sued a lot because of it. And we normally still actually got these cases approved, but we had to take it to the immigration court, where the immigration judges looked at the statute and agreed with us and said, no, USCIS is wrong. Well, USCIS finally reversed course on this and admitted that their interpretation of the statute was just made up and had no basis in the actual law. And so going forward for cases like these, and we see them quite a bit, they should be able to get their adjustments approved at USCIS without having to sue and without having to go into immigration court. So that's good news for lots of people in that situation. If you think that might apply to you, I'd recommend reaching out for a consultation. One thing that's important to note is this does not affect the application of the permanent bar, which is related. It's about unlawful presence, but that's where you accumulate more than 1 year of unlawful presence and then come back without a visa, so without inspection. In that case, you have a permanent bar, which is not affected by this policy change. That's still going to block you from adjusting status. So that's my little update.
Cool. Zach, I know that your update is kind of related to leaving and re-entering, right? So maybe you go next.
Sure. So my updates is about this thing called temporary protected status and the ability to adjust your status based off of temporary protected status. As background, around 1990, the INS back then created this new program for places that were subject to, like, massive disasters, natural disasters, armed conflicts, things like that. So folks who are in the U.S. were able to have some sort of temporary status to allow them to remain in the U.S., to work, to travel with permission, in advance, and to really just kind of wait out these horrible conditions in their home countries. This has been, like I said, over 20, almost 30 years now that this has been in place. Some of the longest designations for temporary protected status have been, 20 years. We've had folks who have been here for almost all of their lives in these temporary protected statuses. And like I said, it's temporary. It's not really a way to get permanent residency. It's not really a way to get citizenship or anything along those lines. But through this really kind of esoteric law called the Miscellaneous Technical Amendments to the Immigration Nationality Act, you were able to travel on this document called advance parole, which you basically just saying, hey, I'd like to travel and I'd like to, before I leave, have permission to come back. When you did that, you were supposed to be admitted back into the status that you were in originally. So the statute specifically says that somebody in temporary protected status will be inspected and admitted back into their status that they were in. What this means is that somebody who traveled on advanced parole would be eligible then to apply for a green card if there was some other underlying basis for it. An employer sponsors them. They have some sort of family member who's able to sponsor them because they have this lawful admission at that point. In order to apply for a green card, you have to have been inspected, admitted, or paroled into the United States. So, this is great. You have this entry now, and you're able to apply for a green card, at least until the Trump administration got rid of it and said that, we know that this statute says you come back as inspected or admitted, but that doesn't really mean inspected or admitted. That means inspected or admitted subject to whatever you were previously as well, as if, there's some sort of status that attaches to coming to the United States without inspection initially. It's a ludicrous interpretation. Everybody who read it was really just flabbergasted that somebody could make this interpretation in good faith. It just makes no sense whatsoever, but it was the law for a couple of years where people who were in temporary protected status could no longer travel on advanced parole, come back, and then be eligible for adjustment of status and to get their green cards. The nice thing is that we have just heard that USCIS is finally getting rid of this. So a couple of days ago, they put out a policy memo saying, we looked at that decision. It's a matter of ZRZC, and we don't think that that's actually a really good interpretation anymore. So we're going to get rid of it. We're going to go back to the old way where, if you come back on advanced parole, you're able to adjust your status. You are inspected and admitted just like is required. And because of that, you are eligible for a green card. They're doing some additional stuff as well. They're changing the advanced parole document to be a specific temporary protected status travel document. So we'll see what that looks like. But overall, it's some really good news for a lot of people because, like I said, some of the longest designations have been, for example, El Salvador was, I think, 2001 when it was designated. So, you have been here since 2001. Perhaps you traveled on advanced parole and are ready to get your green card, but you just couldn't do it because of the timing after this random decision comes out that says, these words don't say what they mean. And now they do say what they mean. And you are able to get a green card if you do travel on advanced parole and you are inspected and admitted on your way back in. So great news all around.
Yeah, what's so wild about this to me is that, if you're not here, you weren't inspected and admitted, then it's possible to get a green card through a family member or business if you do it through consular processing back in your home country, wherever you came from. But temporary protected status is so dependent on something is going on in the home country that we think we should prevent people from being deported there. So it put these people into this place where, okay, the only way that I could possibly stay in the United States, get a green card, is through doing this consular processing. But I come from this country that has a bunch of issues going on. And so trying to do consular processing could be potentially dangerous or just really not an option. And so having this now different route available for having advanced parole and then re-entering and having that lawful entry is a really great thing for people that can take advantage of it. I know that traveling on these sorts of advanced parole things is not always easy to even obtain to get the permission for it. Right now, the Denver field office is overwhelmed with the requests for advanced parole for people trying to visit sick relatives, and we're all trying to make appointments, and they're just like, well, we don't have any appointments right now. So if you can get it, it's great. And it finally makes more sense for these people that are stuck in this situation. So I'm happy to hear that.
And I guess just adding on to that, one of the reasons that this is kind of important is what Aaron was just talking about, the 3 and 10-year bars. So a lot of folks who were here who don't have that initial admission before they got their temporary protected status, they're subject to these 3 and 10-year bars. So if they were to depart and to go to the consulate to try to get an immigrant visa, they wouldn't be allowed back in for 3 or 10 years at that point. So really the only option for staying in the US at that point for them is to have this this immediate option to adjust their status in the United States. And without that lawful entry, without that admission or parole, they couldn't do that. But now they can. So very nice news here.
Cool. For some other happy news, last week the Supreme Court decided not to uphold the injunction that was brought in the Fifth Circuit against the MPP program. So 2 weeks ago, we didn't have our Facebook Live last week, but 2 weeks ago, I had a story about people that tried to apply for asylum at the Mexican border, and then they were turned away. And it was part of the Remain in Mexico, or the Migrant Protection Protocol program that was established by the Trump administration. And the purpose of that program was to keep anybody that is looking to apply for asylum in Mexico while their asylum case was pending. My story a couple of weeks ago was about how people are being definitely taken advantage of. They are in danger of being sent back to wherever they're going to be kept in Mexico, because they are such a vulnerable population that they make really easy targets. And so these people were kidnapped, they were held for ransom, a bunch of them, they were taken to a place where a ton of people similar to them were being held for ransom because criminals knew that these people might have connections in the United States and they had nowhere else to go because they're seeking asylum. That's the entire point of asylum. So it was really easy to get money out of these people. And so the Biden administration had tried to rescind this program, but a Fifth Circuit judge said, no, wait, no, you can't do that, actually. You're violating the Administrative Procedures Act and all this. And so he put an injunction on the repeal of the MPP program. And then that went in front of the Supreme Court. Is this allowed? Is this okay for this injunction to be ongoing? And the Supreme Court said no, that they weren't gonna allow the injunction to go on. It was a 5-4 decision, so it was kind of a surprise to a lot of people, considering the current makeup of the Supreme Court and their current decisions. But they did hold in favor of this program not being allowed to continue on. I don't know. I'm not sure then, given the where this case is at with the Fifth Circuit. So this was all about an injunction, right? So the Fifth Circuit could still potentially do something else to try to get this program to keep going. Is that right?
Well, until the actual injunction is vacated, it's still in place. So it has to go all the way down the courts before it's finally, this injunction is taken care of. So yeah, right now, basically the Supreme Court said you can't do this, but it does have to go all the way through the court system before we have a final resolution there.
Okay. Yeah. And so yeah, it needs to do that. And Biden administration hasn't come out and said, okay, well, when it does get lifted, this is going to be our plan. There are other concerns still with asylum protections. Title 42 was also implemented under the Trump administration, but has been ongoing under the Biden administration. Title 42 is an executive action basically that allowed us, or I mean, gave us a route to expel people that were seeking asylum on the basis of public health. And so this is still being done. A lot of people are still being expelled under Title 42 and not being given the opportunity to make their asylum claims like they should. And so even though MPP might go away, we still need to get rid of Title 42 as well to really give people the opportunity to make their asylum claims in the United States and without being stuck in these very difficult situations. So
Yeah, and on Title 42, they actually extended it. Congress did by voice vote. So it is. I haven't looked that closely, but I don't even think the Biden administration will have the discretion to end it after Congress did that. At least for, I think the deadline is when they lift the emergency declaration for COVID or something like that. So. And that was with full participation of the Democrats, who often made a lot of hay in talking about how bad the Trump policies were when Trump was in power. But there have been a lot of Democrats who have been supportive of Title 42, and so that I don't think is stopping anytime soon. And it's weird because MPP was horrible. It did at least technically allow people to proceed with their asylum claims.
mm-hmm.
Title 42 doesn't. They're just bounced out without anything going forward. So what's worse, I don't know. They're both terrible, but yeah, you're right to identify that that's still going to be a problem.
Yeah, and even the CDC has come out and said, hey, we don't think that people crossing the border are going to be a threat in terms of COVID. So trying to hide behind this public health thing is just absurd.
I mean, the country has almost 100% fully given up on caring about COVID.
Yeah.
No masks mandates anywhere. It doesn't seem like people are being forced to quarantine when they test positive or have symptoms. It's the Wild West, except for this one thing where they say, "Oh, actually, the big threat is immigrants with COVID." So,
yeah.
I guess just to be a little bit of a downer on the Supreme Court opinion as well, some immigrant rights advocates are actually a little bit upset with it because it really curtails the ability of lower courts to implement injunctions.
Yeah.
So, in this case, it's great. We say, lower court, you cannot block the administration's rescission of this policy, but there could be a different situation where there is a really horrible policy that's put in place, and an immigrants' rights organization, for example, might bring suit and seek an injunction from a lower court. And in that situation, based off of the reading of this opinion, it might not be possible for that organization to receive an injunction from the court or a state. Let's say that rather than Arizona suing, it's California suing, and California says, we want this whatever program to move forward, or to be blocked, whatever it may be. Because of that, judge would like an injunction against whatever the administration's doing, this horrible thing. Kind of based off of the reading of this, it seems like that might not be possible until you get all the way up to the Supreme Court, which is it really limits the ability to push back against nasty policies.
Yeah, and it doesn't. You don't have to remember too long ago to remember when organizations were having enormous success in joining Trump policies, at least temporarily. Sometimes they would have success until they got to the Supreme Court, and then not so much. But it still blocked policies for large chunks of time, and sometimes through the Supreme Court, and that's not going to be possible anymore. The other, I think, downside to this opinion is prior to all this, some of the MPP litigation had resulted in a finding by a court in the Ninth Circuit saying that the whole program was illegal, was not permissible under the statutes. And that case actually ended up getting settled after the Biden administration first said that they were going to rescind the policy. So the case is gone, and didn't result in a precedent opinion. But that argument is no longer out there the next time a president is in place who wants to reinstitute the program. This opinion is very clear, saying that it's a viable option. It's at the discretion of the executive. They can implement MPP, or they can parole people in on a case-by-case basis, but both are viable options. And so I don't think future litigants are going to get any traction saying that the program is illegal and that a future president can't use it. But still a win.
Yeah, there's a silver lining there for sure. Yeah. Jennifer, did you want to talk about another decision coming down from the Fifth Circuit?
Yes. So yesterday, the Fifth Circuit Court in New Orleans heard one of the two DACA cases that are up before the courts right now. There is no decision yet, and we don't know when a decision will come. Sometimes it's a few weeks, sometimes it's a few months. But that's one case. There's another hearing happening today. Actually, it starts in like 8 minutes in New York, which is the other DACA case. And so just to kind of give an idea, these two cases are arguing different things. So the one in New York is saying let's backtrack. Okay. So we backtrack, we had DACA, it was implemented in 2012 and it was running, people were getting DACA, people were applying for DACA if they qualified. And then Trump came in and said, no more DACA. And then there's been all this litigation. The Supreme Court said basically like Trump couldn't just come in and get rid of DACA. And so then there was a memo issued by USCIS in 2020 reinstating the DACA program. And then these two lawsuits came about after that. The one in Texas is questioning the entire legality of the DACA program. The one in New York is saying there's a gap between, if people recall, there was a period when that memo came out in 2020 that USCIS was initial DACAs again. And then that stopped when this Texas court case happened. And so this New York case is saying, okay, well, the people who applied, it's about 80,000 people, 78,000 people who applied between December 2020 and July 2021 under that, initial request period being reopened, they should get some sort of relief because these people's cases have been pending all this time since December 2020 or, between then and July 2021, whenever they applied, and they're just sitting there. They've paid the fees and nothing can happen because of an order that came out of this Texas case that was heard yesterday. So it's a little bit confusing because there's two different things happening here. And we don't know what's going to happen with either. The case that was heard yesterday, which is the Texas case heard in New Orleans, isn't great for DACA, to speak lightly about it. And we know that the Fifth Circuit is generally not super friendly to immigration cases. And so we can expect probably an unfavorable decision to come out of this saying, that the DACA policy is not lawful. Even if that happens, this New York case is separate and they're going to be looking at how it affects just those people who are stuck at that 80,000, their initial DACA cases are pending. That's the way I understood it. So we have those two court cases happening, oral argument yesterday in the Fifth Circuit, oral argument today in New York. And then Biden is also supposed to make some sort of announcement. There's supposed to be a rule coming out in August of this year. We'll wait and see what happens with that. Also, Congress, has done nothing. And they've been asked to do something for years and years, and their continued inaction now has DACA really in limbo. And so I think even with a potential action coming out by Biden in August, Congress really needs to do something to help the DACA program to help the DACA recipients, because people can't live their lives on a 2-year by 2-year basis and then have the program be canceled, reinstated. You can apply, you can't apply. Like, it's really confusing for people, and people can't buy homes, they can't start careers, families, because you just don't know what your life is going to be every couple of years. The other issue with the DACA program as it is now is people who are graduating from high school right now, a lot of them are too young to apply for DACA because they weren't, they don't meet those qualifications that were established 10 years ago in 2012. So I think if Biden and or Congress does do something, they need to take that into account as well. I don't know if anybody wants to join in.
Yeah, definitely. I mean, we've talked about DACA a couple of times over the past couple Facebook Lives, so there's just a lot going on right now. I mean, we have these 2 cases going on. We have Biden potentially doing something. We're always hoping for more for them, but I mean, it's kind of a boiling point, I guess, right now of we're seeing all these bubbles rising, and we're going to see what's going to happen, but we still have to wait and see what's going to happen and where it's going to go. So, yeah, it's hopefully some more good stuff, some more silver linings at some point, but we'll just have to wait and see.
I know. I'm pretty jaded on the DACA thing because we keep getting promised that things are going to happen and nothing ever happens.
Yeah, you can't get jaded. You got to stay positive. You got to put out the good vibes, okay? As hopeless as it feels sometimes.
Yeah.
All right. Well, it looks like we don't have any questions for today, so I guess we are good to go, unless anybody else has anything else they want to talk about.
I don't think so. Thanks all.
Okay. All right.
See you next week.
Yeah.
Thanks.
Everybody.